On the record in the Simpson matter, Mr. Simpson is again present before the court with his counsel. Mr. Shapiro, Mr. Cochran, Mr. Scheck, Mr. Neufeld, Mr. Blazier, people represented by Ms. Clark, Mr. Darden, and Ms. Kahn. The jury is not present. Counsel, what are the matters we need to take up before we bring the jury down?
Morning, Your Honor.
Good morning, Mr. Blazier.
Very briefly, Ms. Clark and I have talked about Dr. Reeder's testimony. As you might recall, Dr. Reeder's was in the middle of cross-examination when he had to leave.
I recollect.
And we then called Agent Martz. I want to ask Dr. Reeder's questions about Agent Martz's testimony. He has reviewed it. I've told Ms. Clark that I have no objections if she just wants to start crossing him on that, so we don't need to stop and recall him and that sort of thing. So if that's agreeable with Ms. Clark, that's fine with me.
Yes, I informed Mr. Blazier that'd be fine, that I'm not going to go through the rigmarole of having him leave and come back or walk out the door and come back when he's recalled. That's fine. I'm not going to be able to completely cross-examine him on what he would be saying about Agent Martz because I really don't know until I hear the direct, so I'll have to reserve some of that for cross, but I'm going to make this as expeditious as possible. So.
All right. Anything else we need to take up? Mr. Cochran?
We'll have some things to talk about probably this afternoon, so we get this going. How about this afternoon?
Okay, I had anticipated this morning because I didn't bring the jury down.
Oh, the jury is... Oh, bring your vote in there? Okay, thank you. Your Honor, a couple of things we'd like to address, if we might. One, regarding the tapes, Your Honor. As the court can imagine, we've all been quite busy. I understand the prosecution now has the tapes also. And one of the things I wanted to address was that with regard...
Do they have the tapes and the transcript?
I don't know. I was just advised by Messrs. Schwartz and Regwan that they were going to get, I presume, the tapes and the transcript
Ms.
from
Clark
Ms. McKinney.
indicates that they have both.
Right. And he called and indicated while I was back east this weekend. Your Honor, with regard to that, I would ask, with regard to the people who can listen to the tape, we've obviously got to expand it from the defense standpoint because Mr. Bailey is handling Detective Furman. And we certainly anticipate that he's in the middle of cross-examination, so it's kind of unfair that he can't, he has to know what's on these tapes. And so we've got to extend it further. Because these tapes are so voluminous and there's so much information on these tapes that I believe this court is going to find very, very relevant. We need Mr. Dershowitz and Professor Dershowitz and Professor Ullman also involved because we anticipate any motion they may bring. Clearly they're relevant. And the question is, we don't want to play at this point 13 or 14 hours of tapes. Maybe 5 or 6 hours, but certainly not 13 or 14. But we like to narrow it down. In order to do that, if the court pleases, we want to be able to share that with our colleagues, and we want to do a major brief spelling out the various points and the various relevance. And I think it'll be helpful to the court. We're going to have a copy for you. Well, I should back up and say this. Ms. McKinney's in town, and I had asked her, if you remember last week, to bring the original for this court. And I will, hopefully tomorrow, we can have you the original and a copy of her transcript. And then, as I indicated, my office is doing a separate transcript which we can compare. And but you need to read these transcripts, and it's a lot of work, but you need to hear this for a lot of reasons. And so that's what I'd like to do. And certainly, specifically, Mr. Bailey isn't here this morning, but certainly he has to be part of it because he's going to be.
I agree with you that since Mr. Bailey is the individual conducting the examination of that particular witness, that he ought to be included. Something perhaps we should have thought about when the protective order was originally.
Right.
But the thing is, the protective order was submitted by counsel for Ms. McKinney, Mr. Schwartz, and Mr. Rigwan. So
Yes.
it will need their acquiescence.
Well, it will, and there'll be no problem. I spoke to them from back east, and the other matter that we talked about in the 1054.7, they've acquiesced, they've been in touch, and they will be, they've allowed that also. So I'll ask them to send you a letter today.
All right, if you'll secure for me then their consent to that, with the understanding no copies be made by any of those three counsel, Mr. Bailey, Mr. Dershowitz, or Mr. Ullman.
Certainly. And are there any limits on the prosecution, Your Honor?
The defense, they have not, Ms. McKinney's counsel have not asked for restrictions on the prosecution.
No, that was my understanding. My understanding was they wanted to protect the proprietary rights
Oh, I'm
of
sorry.
these tapes.
No, I
It
stand
had nothing to
corrected.
do with the
Stand
whether it's-
corrected. The protective order did include the prosecution.
All right. Your Honor, the problem with what you just said, and I'd like to just clear this up. Dershowitz is, as the court knows, in Massachusetts, so it's very difficult. We can't work with one copy where he's concerned. So I will address that as soon as I can reach Messrs. Regwan and Schwartz, because obviously we got to send a separate copy to them and they've already acquiesced to a separate copy to others as it is. So we expect that we can handle this if the court pleases. The other matters, Your Honor, Professor Ullman will be here this afternoon, and we'll be talking about the Kessler, Bosco, Savage matters. And I think that Mr. Scheck would like to address the court on the whole idea of the jury view and it's our position it's unnecessary and too costly, but I'd like Mr. Scheck to do that at this point if the court pleases.
All right. Well, here the problem, Mr. Scheck, though, is that the individuals from the district attorney's office who are present aren't here. Why don't you put it in writing, put your objections in writing.
Okay.
All right. All right, the record should reflect that on Sunday evening at 8 o'clock, the court met with Mr. Scheck and Mr. Douglas and Mr. Yokelson and Mr. Hodgman, and the five of us went to the Bundy and Rockingham locations in the evening hours to view Bundy and Rockingham for the purposes of determining whether or not a nighttime viewing would be appropriate in this case. And I'll take up any objections or suggestions from counsel in writing, but we should resolve this issue by Wednesday. All right, anything else before we bring the jury down?
Yes, Your Honor, we should approach that
On what issue?
on the tapes issue.
We're not going to discuss the content of the tapes, are we?
No,
I mean, is there anything we can't discuss here in open court?
yes, it is something that we can't discuss here in open court.
Why is that?
Yeah, I really, I think we should address this at sidebar.
All right, with the court reporter, please. And Deputy Jacks, would you make arrangements to have the jury brought down, please? Simpson matter, all parties are again present. Jury is not present. Record should reflect we've had an in-chambers conference on the record regarding the alleged tapes and the well, at this point I haven't seen them yet, so in my mind they're still alleged. All right, thank you, Mr. Shapiro. And also the conflict issue that's raised has been raised by counsel. All right, anything else that we need to discuss before we continue with Dr. Reeders?
You want us to put it, may I have a second? with regard to this whole matter of the affirmative tapes, and I can tell you they do in fact exist, we will also be preparing, as the proponent of the evidence, a brief for the court, setting forth those things that we think are very relevant, and there are numerous, but we understand the areas that the court has previously indicated would be relevant. There's one other thing, Judge. There's this overall category of credibility, where a witness may have said something on the stand which we can now disprove. There's also something else these tapes bring to mind, and that is this particular officer's entire personnel record and what's in it, or what should have been in it, and what this court may not have seen, based upon the numerous incidents he talks about of physical violence and force he's been involved in. And so we have a number of things to go back and look at. And then finally, you'll recall that when this particular officer tried to get off the LAPD and told about all of his violent proclivities and his racist views, that was discounted by the LAPD, who basically said, well, we don't believe you're a racist, we believe you're a liar, go back to work. And the point then becomes, some of those things may now be very relevant by what we now learn out of his own mouth. So there's a number of issues that we want to kind of focus on and then get back to the court on as we resolve these and move ahead as quickly as possible.
All right, I realize that there's a large circle of items that are potentially
Yes.
included here.
Fine. Thank you.
All right. All right, let's have the jury, please.
You asked us to put something in writing. Will the court allow some argument on that also?
Absolutely.
All rise.
All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. My apologies to you for the late start this morning. However, I've been meeting with the lawyers in chambers to discuss some issues that may be coming up that I have to deal with, and to advise you that there may be some other delays later this week, as I have some other issues I need to deal with. All right, we have Dr. Frederick Reeders back with us. Good morning, Dr. Reeders.
Good morning, Your Honor.
All right, would you take the witness stand, please? All right, the record should reflect that Dr. Frederick Reeders is again on the witness stand. And ladies and gentlemen, if you recollect, on July the 24th, Dr. Reeders presented his direct testimony under questioning by Mr. Blazier. And on July the 25th, we started the cross-examination by Ms. Clark. And because of Dr. Reeders' other commitments, he had to interrupt his cross-examination, completion of his testimony, and we are going to conclude his testimony this morning. Having said that, good morning, Dr. Reeders.
Good morning, Your Honor.
Doctor, you're reminded, sir, you were still under oath, and Ms. Clark, you may continue with your cross-examination.
Thank you, Your Honor. Good morning, ladies and gentlemen. Good morning. Good morning, Dr. Reeders. When we left off in your testimony on July 24th, sir, we were talking about the Sconce case, a case in which the victim they were attempting to determine whether or not the victim died of natural causes or of oleander poisoning. Do you recall when we were discussing that, sir?
I wasn't trying to determine whether he died of natural causes. I was trying to determine
Sir,
whether
could you
there-
please listen to my question of the objection motion to strike as non-responsive?
All right, stricken, juries to disregard. Ask the question again.
Do you recall that we were discussing that topic when you last testified on July 24th, sir?
That's not the way I recall it.
It's prior testimony.
All right, he's indicated that's not how he recalls it. Next question.
Do you recall that you were asked to test some tissues to determine whether or not the victim died of oleander poisoning in the case of People versus Sconce back in 1988?
That's not the way I recall it.
What do you recall?
I recall that Dr. Baselt asked me to corroborate or negate analyses which he had done for a coroner to determine whether or not oleander constituents were present in tissues.
And what was the point of doing that?
For the authorities to decide whether or not this was a natural death or not,
All right, and that's precisely
or
what
to
I...
help them to decide.
All right, and the reason that you were asked to do that, sir, is to provide scientific evidence that would indicate whether or not the victim had died of oleander poisoning or of natural causes. Isn't that true?
That was the apparent intention of the DA, yes.
And so you did perform those tests on tissues back in 1988, correct?
I performed the analysis in 1988, that's correct.
And you performed the analysis on tissues that were recovered from the 1985 autopsy, correct?
That had been in the freezer since 1985, right.
Is it your testimony, sir, that it had been in a freezer since the time that those tissues were taken in autopsy in 1985?
That's what Dr. Lovell told me, yes.
Sir, do you recall performing some of your testing on the fixing fluid known as formalin?
Yes,
And that fixing fluid is used to preserve tissues that are refrigerated and not frozen. Isn't that correct?
that fluid is used on tissues which may not even be refrigerated, which are kept in a glass jar in storage for making sections. But the tissues that Dr. Lovell sent me, or rather the Dr. Baselt sent me, because I got them from Dr. Baselt, according to him and Dr. Lovell, had been kept frozen.
And they were kept frozen in the fixing solution called formalin?
No.
Then why were you testing formalin for the presence of oleandrin?
I think that that was in addition to tissues. I don't remember why, but the formalin that I received evidently had been in contact with the tissues, because I believe it turned out to have oleandrin in it. I'm not sure about that. It's one of the pieces that goes with the case. That's all I recall, can tell you.
What would be the purpose of having formalin? Why would you have formalin if the tissues were frozen?
Because the formalin would reflect the environment of tissues that were kept in formalin, I assume, or else the formalin was material used for embalming the body. I don't recall. Either one happens all the time, that with old cases one gets a sample of formalin, either from tissues, from wet tissues as they call it, or from the embalming fluid.
Is it your testimony, sir, that they put tissues taken from a victim at autopsy into formalin and freeze it in the formalin?
No, I didn't say that.
All right, so if you had formalin fluid
Excuse me, I made it very clear before that the tissues that are put in formalin are usually kept on a shelf, not even refrigerated.
then the fact that you tested formalin fluid from the tissues taken from the victim in the sconce case would indicate that they were not frozen right away, wouldn't it?
It doesn't indicate anything except that I got some formalin, which could have been embalming fluid, or it could have been formalin in which tissues were fixed.
Nevertheless, you did test the tissues and the formalin that was recovered from the 1985 autopsy, correct?
I'll refresh my memory.
And exactly what is it you're trying to refresh your memory about at this time, sir?
Whether or not I tested formalin.
And the file that you're looking through, sir, is that your file from the sconce case?
Yes. What's left of it?
You don't have the entire file there?
Not here, no.
Where do you have the entire file, sir?
The entire file, or the rest of all kinds of extraneous things in addition, is in the hands of Mr. Blaze.
Mr. Blazier?
Yes.
And when did you give Mr. Blazier this file, sir?
When I got here,
Sustain.
Your Honor, I'd like to...
This is far afield about formalin and whether or not it was tested.
I'll withdraw the question, Dr. Reeders, about formalin.
All right.
Yes.
Next question.
I analyzed it as fixing fluid. That's what it was.
Okay, and that's formalin, isn't it, sir? Fixing fluid?
In this case, yes, there are other fixing fluids.
Okay. So you did analyze that in this case. And that would tend to indicate to you... Never mind, strike that. When you got the tissues, sir, were they frozen?
Yes.
And
The tissues I got as homogenates and as blood, they were frozen. They were shipped to me frozen by Dr. Bessel.
And you maintained them in a frozen condition, did you?
Yes.
And then you...
Except for sampling.
All right, and you performed 3 tests, correct? The radioimmunoassay, fluorescence spectrometry, and thin layer chromatography, correct?
Fluorescent spectrophotometer, yes. And thin, high performance thin layer chromatography, which is loaded.
All right.
All right, Doctor,
Now, those tests...
Hold on. Why don't you swing the microphone?
Oh, sorry.
Now, those tests were the state of the art back in the 60s, weren't they?
60s?
Yep, 60s.
Oh. What's the relevance of the 60s? This is test done in the late 80s.
I know, Your Honor.
Proceed.
And
No, proceed.
that's the point.
Proceed.
Actually, in the 60s,
Wait,
I'm sorry.
wait. Proceed.
Do you recall, when you began practicing as a toxicologist, that was in the 50s, is that correct, sir?
In the 40s.
In the 40s. And in the 60s, what was the state of the art testing?
Sustain.
All right. When you performed those tests, the result you got was positive for the presence of oleandrin, correct?
Yes. And oleandrogenin.
And oleandrogenin. All right. Now, the presence of oleandrogenin is an important fact, is it not, sir?
In the identification, yes.
And that's important because when you have decayed or decomposed tissue, the substance oleandrin may break down into a metabolite, in this case oleandrogenin, so that even if you don't have oleandrin, if you have oleandrogenin, you can still substantiate that it was present. Isn't that right, sir?
No, ma'am, it's not right, if I may correct you.
Well, if it's not right, sir, then let me ask you another question.
Well, let me explain, if I may.
Wait, no, hold on. He can answer the question. Answer the question, Doctor. Go ahead.
I said, no, that is incorrect. May I explain what is correct? Oleandrogenin is formed in the body as well when you take it, when you take oleandrin into the body. It is also formed in the plant itself, in the oleander plant itself. It also is formed if oleandrin starts to break down for any other reason. So in this particular case, the issue was not whether this was a decomposed tissue, but whether or not there were compounds present which would give a pattern, which is more important than just a single compound, that is consistent with and therefore corroborative of having originated in oleander constituents. That's what the oleandrogenin means in this case, that on the thin layer chromatography, that plus some other metabolites or breakdown products of oleandrin were found, giving a pattern which gives a high degree of identifiability to the compound, because you have a whole pattern rather than just one little streak.
All right, next
So then the finding of oleandrogenin was an important corroborative tool for you to determine that, in fact, it was oleandrin that you saw.
352.
It was one of them, yes, of course.
Do you have the report that you submitted on the case concerning your findings?
All I have is the handwritten report. I don't have any of the typed copies. Or a copy of the handwritten report, I should say.
All right, Doctor, I'm going to show you the report that you actually, typed report that you wrote, that you did back in the Scott's case. And a copy to counsel. I'm going to show you a copy as well, Doctor, and I'm going to ask you to point out where, in this report, you determined that you found oleandrogenin.
It's not in the report.
It's
But
not
it's
in the
it's in my notes.
It's not in the formal report, Doctor?
No, it is.
Sustained. Rephrase the question.
You acknowledge that's an important finding, the oleandrogenin, yet you did not put that in your report.
It wasn't important to the report. It was important to my conclusion of the report to have enough factors to call this with reasonable certainty the presence of oleander.
And let me ask you then, Doctor, why was it not important to put in a report when you just acknowledged that the constituents of oleandrin were an important corroborative tool?
Sustained. Rephrase the question.
You did not put that into your report to Dr. Lovell?
Overruled.
Is that right?
Is what right?
You did not include the finding of oleandrogenin in your report to Dr. Lovell. Is that correct, sir?
Hold on a moment. That is correct.
Now, Dr. Lovell, he was a coroner back then. Is that correct?
That's correct. Pathologist. And
Pathologist. And he had signed off on the report back in 1985 in which his medical examiner, Dr. Holloway, determined that the victim died of natural causes, actually from a fatty liver disease, correct?
I don't have any of that information.
Foundation.
Doctor,
He's indicated he has no other information.
Did you read the autopsy report created by Dr. Holloway back in 1985?
I don't recall, and I don't have a copy of it.
You don't recall? Did you remember testifying in the Sconce preliminary hearing, do you not?
Yes, I remember testifying in it.
And you recall testifying that you had in fact read that autopsy report?
I don't recall it, but if the transcript says so, then I did. I'm telling you, I don't recall.
Would it refresh your memory, sir, if I were to show you a page from that preliminary hearing in which you
Possibly.
acknowledge that you read the autopsy report?
Well, I don't deny that I read it. I don't recall that I read it, and I don't have a copy now of the autopsy report. That's all I told you.
Well, then let me show you a copy of the autopsy report, sir.
Sustained. It's irrelevant.
May I be heard, Your Honor?
Nope.
Were you aware at the time that you did your testing, sir, that there had already been an autopsy report prepared in which it was written that the victim died of natural causes?
Foundation, irrelevant.
Sustained.
Sir, when you testified at the preliminary hearing, you recall testifying that there had been an initial determination that the victim died of natural causes based on the autopsy report, correct?
Counsel, I don't know what the relevance is of this because we've already established the reason he was doing this testing was to determine whether or not this person died as a result of oleander poisoning, not natural causes. So the jury already knows that. That was the purpose of this testing. So let's move on.
Goes to the nature of the report, Your Honor.
The report is not real relevant.
All right, Dr. Reeders, nevertheless, you acknowledge you did not put the finding of oleandrogenin into your report.
Sustained.
All right. You did put it, however, in your notes. Is that what your testimony is?
It was part of the thin layer observation, important part of it, just
And-
like in the paper that we wrote.
Can you show me the notes that you're referring to?
Well, maybe. I don't know what it's about. sheets and the thin layer results, or the thin layer laboratory notes on it. None of the lab notes.
All right, Doctor, why don't you swing the microphone around?
So you have nothing in the notes now before you that indicate that you found oleandrogenin.
That's what I said, yes.
And in your testimony at the sconce preliminary
I have
hearing,
nothing in my notes of what of the actual description of the thin layer plate.
you recall testifying at the preliminary hearing in the sconce case, sir, you never mentioned the finding of oleandrogenin, did you?
I don't recall. I may not have.
And if we take time over the break and I let you review the testimony that you have in the sconce matter, you can refresh your memory as to whether or not you did, in fact, testify to that finding.
And ask to
Sustain.
approach.
No. Sustain. It's irrelevant.
Okay, Dr. Reeders? Do you recall having a conversation with a man by the name of Dr. Brian Finkel in Anaheim back
Yes.
in 1990?
Yes,
And that man was a toxicologist for the defense in the sconce case, is that correct?
yes,
And you recall telling him that you found one spot on your thin layer chromatography which would indicate you only found oleandrin and not oleandrogenin.
absolutely not. I have a rather clear recollection of my conversation with Brian, and that is not what I told him.
So if he came and told us that, sir, that would be incorrect. Is that your testimony?
Objection, improper question, argument.
Overruled.
If that's what he told you, he's mistaken, or else.
All right. Now, you turned in your report indicating the finding of oleandrin, correct?
The quantitative finding of oleandrin, yes.
And after that, you testified at a preliminary hearing in October of 1990 concerning your finding, and that was concerning your finding of oleandrin in the body of the victim, correct?
That's correct.
And shortly after that, the defense and the prosecution agreed to do retesting. Do you recall that?
I don't know how shortly afterward it was afterwards, yes.
Well, you testified in October of 1990. The defendant was held to answer, and the testing began in the beginning of 1991. Does that sound about right to you?
I thought it came in April of 1991. Because when we met in, I think, Anaheim, and Brian Finkel and I went over what I still had left, they hadn't done the testing yet. They hadn't contacted the testing people yet.
All right. Before they did the testing, though, the body of the victim was exhumed, correct?
It wasn't exhumed, it was lying exposed in the mausoleum.
Mm-hmm.
So it was pulled out of the mausoleum and re-autopsied, what was left of it, by Dr. Lovell and a Dr. Root. And at that time, specimens were taken from that cadaver, and those are the specimens that were then forwarded for testing.
Now, Dr. Reeders, you were aware of that exhumation, well, for lack of a better term, exhumation, but you were not present, correct?
At the time, I wasn't aware of it. I certainly wasn't present.
You were or were not aware of it?
I was not. Not
When
at
did
the
you
time.
when did you become aware of the exhumation?
When Dr. Lovell called me and told me that he had done an exhumation with Dr. Root, and that they had taken specimens, and the half that Dr. Root had was going to Jack Henyon at Cornell, and the other half he was going to send to me for safekeeping.
Send to you? Exhumation tissues to you?
For safekeeping, yes.
And why would he send exhumation tissues to you, Dr. Reeders?
Ask him.
All right. Were you planning to do testing on it?
No.
So you were just supposed to keep them? Hold them?
Well, that's what he asked me to do.
Can you think of any reason why Dr. Lovell would not keep those himself at the morgue?
Objection calls for speculation.
Sustain.
All right. Now, shortly after that exhumation, sir, were you informed by the DA that the testing performed by Dr. Henyon for the presence of oleandrin turned up negative?
Harvey Giss, yes, notified me.
All right. Do you recall also talking to a prosecutor by the name of Kevin Denos?
I don't recall. The only thing I recall about Denos is two things. One, that I was supposed to contact him prior to trial, but to wait. The other thing I recall is that he sent, through Harvey Giss, a paper to me which he asked me to review whether or not that could be a basis for questioning the results. And that was a paper that dealt with a substance that is called natriuretic, N-A-T-R-U-T-I-C hormone, which tends to cross-react with digitalis and probably oleandrin in the radioimmunoassay test. That's the only thing I recall about the notes. That's the only question that he raised.
You don't recall discussing with Mr. Denos the reason, well, let me strike that. You don't recall Mr. Denos calling you to ask you to give him a scientifically acceptable reason that would reconcile your positive results with Dr. Henyon's negative results?
Absolutely not. Nobody asked me to reconcile anything.
No one asked you to reconcile anything?
And nobody talked to me for practical purpose after that, as far as I recall.
Sir, I have a memo here from Mr. Denos that I'd like to show you. Let me direct counsel to page 6. Bottom of page 6, going up through all of page 7.
All right, this is a memo from Mr. Janos to the Dr. Readers.
Yes, Your Honor, I'd ask it to be marked next in order. No, this is to his boss, Michael Bradbury.
All right, Jack, and have to approach.
Wait, it's a memo from Janos to Bradbury?
Right. It's a memo from Kevin Denos to Michael Bradbury and Harvey Giss,
All right,
in which
okay.
people's next in order.
I object and ask to approach.
All right, with the court reporter. All right, thank you, counsel. Ms. Clark, that'll be marked, that memo will be marked People's 585.
Thank you, Your Honor. Now, Dr. Reeders, is it your testimony that neither Mr. Giss nor Mr. Denos, neither of the prosecutors ever asked you to reconcile your positive findings with Dr. Henyon's findings?
That is correct. The only one who spoke to me were two people. One was Harvey Giss, the other one was the investigator from Simi Valley, Ventura County, or L.A., the chief investigator of this case, the police investigator, I believe.
Oh.
Those were the only two people who spoke to me, neither of which asked me to reconcile it. Quite to the contrary. If I may, I can tell you what they did, what I was told.
Well, we can go back to that if you want, Doctor. Right now, let's...
Title to finish.
Dr. Reeders, it's my question to you is only this. After Dr. Henyon's results came out, found no oleandrin,
You're right.
is it your testimony that no one asked you to reconcile the difference between your finding and his? Is that your testimony?
That is absolutely the correct thing.
I'm going to show you, you have no memory of that whatsoever.
None whatever that anybody asked me to reconcile.
All right, Doctor, I would like to show you this memo written by Mr. Denos. And tell me if the representations he makes concerning statements made by you refreshes your memory and is true or false.
Ms. Clark, that's actually not a question. It's a question, does that refresh his recollection? That's the only question, not the content of the memo.
Does that refresh your recollection, sir?
Give him a chance to read it.
May I read it?
Yes.
Well, I'll let you know when I'm done reading it.
All right, let's stop that.
All right, I've finished reading it. What's your question?
Do the passages which I've just pointed out to you that you can see bracketed here in black on pages 6 and all of page 7 refresh your memory as to a conversation you had with Mr. Denos concerning your attempt to reconcile the results between yours and Dr. Henyon's?
Not only does it not refresh my memory, but I'm reasonably certain that I did not have this conversation with Mr. Denos.
Could you have had this conversation then with someone else, Dr. Reeders?
No.
Then it is your statement here that the statements attributed to you never happened.
Objection.
Sustained. It's without foundation.
My statement...
Wait,
I'm
wait.
sorry.
I will sustain the objection. Next question.
May I have a moment, Your Honor? Then you offered no explanation to anyone back in 1991 to attempt to reconcile your results with Dr. Henyon's.
I don't know what you mean by I offered no statement to anyone. Of course I talked to people about it. And I pointed out that his test had nothing to do with my test. He tested pieces of fish-like and rotten meat-like leftovers from a body that had lost more than a half of its weight in decomposition taken years later than the specimens that I had tested. And to expect a positive result in a case like this is very much wishful thinking.
So it is your testimony, sir, then, that you did tell people that back in 1991 that Dr. Henyon tested only the tissues from the exhumation in 1991. and that's why he got a different result. Is that your testimony?
We both tested tissue, I'm sorry, from 1991. I don't know what else he tested. I don't see anything else in there except maybe the formalin fluid that, I don't know whether he tested that, but he tested tissues that Dr. Lovell had obtained from the decomposed remains of waters. That's what he tested. It's in the report.
All right. In your opinion then, sir, is it your testimony that back in 1991, you spoke to people and you told them that the reason his negative result occurred is because he tested the older, more decayed tissues removed in 1991? Is that your testimony?
I told him what he did and what I did, and that expecting to find anything in those tissues was wishful thinking, yes. My staff I talked to about.
So your answer is, sir, yes, you told people in 1991 that Dr. Henyon tested the tissues recovered from the victim at the exhumation in 1991, and that's why you got different results. Is that your testimony?
That's my recollection, yes.
And who is it that you told that to in 1991?
My staff.
Calls for hearsay.
Sustained. Sustained. Proceed.
Did you inform no one on the prosecution that that was the reason for the negative result that he got?
I didn't talk to anyone on the prosecution after that, for good reason.
And what was that good reason, Dr. Reeder?
Irrelevant.
Sustained.
Did you call Dr. Henyon in 1991 to attempt to reconcile those results?
After the analysis, no.
Now, in reviewing the documents, sir, that I showed you, People's 585, nowhere in this document does it indicate an explanation that Dr. Henyon...
Sustained. Sustained. Foundation.
Doctor, would you agree that the testing of older tissue that was substantially decayed that gave a negative result for poison would be a scientifically acceptable basis to explain the discrepancy in results?
Would you repeat that, please?
Yes. Would you agree, doctor, that the explanation that Dr. Henyon tested the older, more decayed tissue would explain in a scientifically acceptable manner the reason why he got negative results and you got positive results?
Certainly.
And that explanation would reconcile the difference and allow your findings to remain valid, wouldn't it?
As valid as they were before.
Oh.
Yes.
Your Honor, I need to approach.
With the court order. Proceed.
All right, back in 1991 then, you wrote, may I ask you, sir, did you write any letter to the district attorney to explain to him what you've explained to us, the reason for the discrepancy in yours and Dr. Henyon's findings?
I don't recall that I did. I don't think so.
Then did you write any letter to Dr. Lovell back in 1991 to explain that there was a valid, acceptable scientific reason for the discrepancy in your results?
I don't recall that I did.
Did you contact Dr. Henyon?
Excuse me, hold on. Doctor, would you pull the microphone around front there, please? Thank you.
Did you contact Dr. Henyon to discuss with him the discrepancy in your results back in 1991?
1991? No, I did not.
Did you write him a letter back in 1991 to ask him to discuss with you the discrepancies in your results?
No, I think we were both on a program at the Pittsburgh conference subsequently and talked about it a little bit then, but that's the only time, I think, other than very recently, that I talked to Jack Henyon.
Now, you knew that you were to return to complete, and when was that Pittsburgh conference, sir?
I think 92, I'm not sure. We were both on the same program.
Did you have any knowledge of the status of the sconce case back in 1991?
Sustained.
Okay. All right, you knew you were to return to this court to complete your testimony today, August 14th. Is that right, sir?
Yes.
And you called Dr. Henyon on Friday, August 11th, this past Friday, did you not?
Yes.
And you called him for the purpose of discussing his findings in the sconce case. Isn't that correct?
No.
You called him to discuss what tissue he had tested in the sconce case. Isn't that correct?
No.
You called him to get him to agree that he tested the exhumed tissues and not the autopsy tissues. Isn't that correct, sir?
No.
Did you discuss with Dr. Henyon on this past Friday, August 11th, what tissues he had tested back in 1991?
It came up, yes.
And that was the first time you'd ever called Dr. Henyon. Isn't that correct?
Yes.
And you tried to get him to say that he had tested exhumed tissue and not the autopsy tissue that you tested. Isn't that correct, sir?
Objection. The form of the question's argumentative.
Sustained. Rephrase the question.
Did you tell Dr. Henyon that you believed he had tested the exhumed tissue and not the 1985 autopsy tissue that you tested?
I didn't tell him I believed that. I told him that that's what was in his report then, which I had in front of me. He didn't have his in front of him.
And he disagreed with you, didn't he, Dr. Henyon, Dr. Reeders?
Well, he argued about it. He said he'd have to look it up. That's all I know.
Isn't it true, Dr. Reeders, that he told you that his notes and his memory, he recalled distinctly that he had tested 1985 autopsy tissues? Didn't he tell you that, sir?
I don't believe he told me that. He told me he thought he might have tested other tissues and he would check it out from his report, which I have here.
You don't recall him telling you that he did in fact test the autopsy tissues?
He told me he thought he might have, and he'll check his report.
Did you also ask him to sign an affidavit to the effect that he tested only the exhumed tissues and not the autopsy tissues?
No. I asked him to verify what was in his report in an affidavit, current affidavit, and to add to it also, which is in his report, that oleandrin is not a substance which is resistant to degradation by putrefaction, which he agreed. But he didn't agree to write an affidavit, but he agreed that it was, as he did in his report.
Isn't it true, Dr. Reeders, that he refused to sign the affidavit because it was not true, because he did test tissues taken from the 1985 autopsy?
Absolutely not. He said he didn't want to have anything to do with you or me or anybody else in this case. He was sick and tired of it. That's what he said.
Sir, did he tell you that he'd spoken to me?
He said he'd been pestered by the prosecution from hell to breakfast. I'm quoting him.
Is that Dr. Readers, you wanted to convince Dr. Henyon that he had tested older tissues, because if that is not the case, then the explanation you gave to this jury is wrong. Isn't that correct?
Maybe had one question at a time. I did not try to persuade him anything, and so that the second part really isn't relevant to this.
All right, let's wind up this area of inquiry.
Now, back in 1991, sir, you were made aware of the fact that Dr. Henyon used the LC mass spectrometer. You recall that?
Sure, yeah.
And in matter of fact, at the preliminary hearing, didn't the defense attorney cross-examine you as to whether or not you thought the mass spectrometer could be used to test for oleandrin?
Objection, irrelevant.
Sustained. Ask him a contemporaneous question.
I'm sorry?
Ask him a contemporaneous question. What's his opinion about whether or not that would have been a useful scientific technique at that time on those samples? Whether or not there are any advantages or disadvantages. That's the only relevance to that question.
I was just about to get to that. In your opinion, sir, when you were asked at the preliminary hearing about the use of the mass spectrometer to test for oleandrin, would that have been an effective or more effective means of testing for the presence of that poison?
I don't recall that that issue was raised, but had it been raised, I would have informed the court of the fact that that I was unaware of any published method for determining oleandrin by gas chromatography mass spectrometry. That probably a liquid chromatography mass spectrometry method might be more applicable. I'm unaware of that. I was unaware of any published method, and furthermore, I was unaware of anyone, myself, certainly in the post-mortem forensic toxicology community, who had such equipment at that time available. It was relatively rare.
And so, as a matter of fact, you did not believe that anyone had that equipment at that time?
No, I didn't say that, please. Don't put word in my mouth. I said that in the forensic post-mortem toxicology community, medical examiners' laboratories, coroner's laboratories, I don't know about the FBI, but my colleagues weren't using LCMS. The one case where LCMS was used in a post-mortem case, it was done by Hewlett-Packard out here for somebody that I knew of. So it wasn't a tool that was generally lying around available to anyone at the time. And also, what I want to emphasize is that I was unaware of any published report of an analysis for oleandrin in tissues by either GCMS or LCMS. And so I couldn't say that it could be done.
Next question. Let's wind this up. Let's try the Simpson case sometime today.
Dr. Readers, would you agree that someone who was familiar with the operation of that machine would know how to devise a test that would be effective, or perhaps would know how to devise a test that would be effective for the presence of oleandrin?
Sustained.
What effort did you make, sir, after hearing the questioning at the preliminary hearing or at any time before 1991, to determine whether the MS could be used for the testing of oleandrin?
I asked a couple of my colleagues whether they had anything available that could do the job. None of them did, and that's it.
I'm sorry, sir, what did you say?
I said, I asked some of my colleagues whether they had any such method for oleandrin available at the time, LCMS, and none of them did. That's as far as I went.
And what effort did you make to determine whether or not Dr. Henyon's method was an effective one after you learned of his negative result?
Sustained.
Did you make any effort, sir, to send your tissues, the autopsy from 1985 tissues, to Dr. Henyon for testing on the LCMS to confirm or refute the findings that you had?
That's what I proposed before the autopsy tissues were, before the exhumation was done. I proposed it first to Harvey Giss when he came up with Henyon's name. I knew Henyon, and I knew of the, by that time I found out that he had methodology available, and I offered some of the specimens that I had. I again suggested that, I think, to Brian Finkel and to Dr. Lovell, and they turned that down. They said, and I was told on the telephone,
All right,
no.
Doctor, the question was, did you offer any of the tissues?
I sure did.
All right, next question.
And you say you offered those tissues to the defense, correct?
I didn't talk to the defense. I showed them to the defense. The defense attorney, Diamond, came to see me, and I showed him. I had them wrapped tightly, sealed, signed, and everything in the deep freeze. Yeah.
All right.
And he rejected them.
Wait. This is the end of this inquiry. It's completely irrelevant at this point. Move on to something else.
All right, Dr. Reeders, in this particular case, you did not do any testing on any of the evidence. Is that correct?
On what?
In this case, in the Simpson case,
No.
did you do any testing on any of the evidence?
No, I didn't.
You just interpreted the tests that were done by Agent Martz, correct?
That's correct.
And those tests were performed on equipment that you have never operated, correct?
Yes.
Now, with respect to the finding on the gate, you indicated that you found the single parent and single daughter ion, correct?
Testimony.
Oh,
I'd have to refresh. I have to see what he had, whether he ran a chromatogram where he ran, whether that's the one where he ran all three or whether it was on the sock. And where, in my opinion, it showed the third daughter ion as well. I don't know whether it was this one or the other one.
All right, let me just ask you this. With respect to the single parent and single daughter ion, would you agree, sir, that there may be other compounds that are not EDTA that have that single parent and single daughter?
Possible. I don't know of any.
I'm sorry?
I said it's possible. I don't know of any. I couldn't find any either.
And isn't that also what you said in the Sconce case?
Beg pardon?
Isn't that also what you said in the Sconce case?
I don't know what you're talking about.
When you were asked whether it could have been another compound besides oleandrin, you said it could be, but you don't know what that would be. Isn't that right?
Probably, yeah, that's true.
I'm going to show you a copy of the report you prepared in this case. Do you have it with you, sir?
I don't know what I do about it. No, I don't.
Perhaps Mr. Blazer has an extra copy. Going to mark this as People's 586.
586. Don't we already have this report marked?
I don't think so.
All right, 586.
Let me ask you a couple of questions about this report, sir. You recall that you wrote this report on July 17th, 1995, correct?
I don't recall the date. May I have a copy to refresh my memory?
Mrs. Robertson, would you make an extra copy, please?
Let me
All right.
show you the date on the... All right, you see the date, sir? And the name, Mr. Blazier?
Yes.
Let me ask you something, Dr. Reeves. You don't have a copy of your own report in this case?
Not anymore. I thought you were going to examine me on the sconce case today, so I brought the file with me.
Why don't you look at this? Does that appear to be your letterhead, sir?
Yes.
And does that appear to be the report that you wrote for your findings in this case?
Yes.
And is that dated July 17th, 1995?
Yes.
And then would that be the date that you wrote the report?
Yes.
Now, that report was an accurate summary of your findings. Is that correct, sir?
Yes.
And you received the graphs of the test done by Mr. Martz, you indicated, I think, back in March of 1995.
Sounds about right.
How many hours did you spend reviewing all those charts, sir?
Endless hours.
Can you tell us how many?
Well over 50, I know that.
You billed for your time, did you not, sir?
Some of it.
And how much time did you bill for?
I may have billed a total of 15 or 20 hours.
Out of the more than 50 that you spent? So you basically donated half your time in this case?
No. No, I didn't donate my time. I used it effectively to learn something, and so I didn't charge them for that, all right?
So how much did you bill for your work in this case, sir?
I think the total that we've built so far may be around, I don't really know. We built $250 an hour for chargeable, forensically active work directed towards it. I think it's under $10,000.
You billed under $10,000?
I believe so.
And how much do you bill for each day you spend in court?
$2,500.
And so this is your second day in court, correct?
In court, actually, it's, I don't know, it's the second or third day. Haven't billed any of this yet.
Do you intend to?
Of course.
So when all is said and done, your billing will have been about, conservatively speaking, $15,000?
I'm sure it'll be more than that.
Do you think it'll be around 20?
I don't know. I'll bill it by time and my record. That's all I can tell you.
All right. So you spent over 50 hours reviewing Agent Martz's chart.
Yeah.
And then you wrote this report on July 17th,
Yes.
which accurately summarizes the findings of the results of your examinations of those charts and graphs, correct?
It's my opinion and not findings. He made the findings. He
Findings.
put them in his chart. I reviewed them and came to a conclusion based on those findings, yes.
All right. And the report summarizes your opinion of his test results, correct?
Evaluation and opinion, yes, that's correct.
All right, let's look at what your report says, sir. I'm going to direct your attention, this is the first page of your report, to your opinion of the test results on the back gate stain. Specifically, sir, to Roman numeral 3. Your opinion in that paragraph is that you found one daughter ion, correct? And one parent ion that's in paragraph 2. Is that right?
No, that's not what I found. I described the one daughter ion in paragraph 3, that it corresponds to the daughter ion of the EDTA standard.
Right. And then in paragraph 2, just above it, you said you found the one parent ion that corresponds to the EDTA standard, correct?
I didn't say I found anything. I said a mass spectral ion corresponding to the parent ion of the EDTA standard was present in the packet.
And that was your opinion concerning the gate stain, correct?
No, this is a description of facts that were in the packet that I got. This is not opinion. That's just a description.
Is that your opinion,
It's
sir? You looked at the graphs and this is how you interpreted them, correct?
It's not only how I interpreted them, but that is also what Roger Martz agreed to, that with me, that retention time corresponded to the EDTA standard, that the mass spectral parent ion corresponded to the parent ion M+1 of the standard, and that the one MS ion that he monitored individually, the 160, also corresponded to that of the EDTA standard. These are things that he states in his chromatography in his report.
All right. And so this, as to this stain, we have one parent and one daughter, but not the full daughter spectrum, correct?
It says what it says. They have it in their full daughter spectrum. This doesn't refer to it.
Dr. Readers, this report, paragraphs 2 and 3,
Right.
does this show one daughter and one parent, but not the full daughter spectrum was revealed by the graphs?
I'm sorry, that's not correct. It's not in the report. I didn't refer to the full daughter spectrum because it was such a mess. But it was still there. I had seen it.
Sir, have you reviewed the testimony you gave on direct when you were last in this courtroom?
Well, I went through the tape, yes.
Do you recall testifying that you found the full daughter spectrum on the gate stain?
I think I testified that in looking at the full daughter spectrum, that I recognize all three ions as showing on it, visibly.
Are you sure of that, sir?
I thought that's what I did. I don't know, as I said, I don't know whether it was the gate or the sock. Remember, I told you that. So I don't know which one it was. But on one of them, I said that.
On one of them, you recall saying that, correct?
Yeah.
Then, let's assume for a moment, sir, it was the sock. Okay?
Okay, so that's the, so that would be number 2. Right.
All right, then number 2. Let's go to page 2, sir. Because if according to your testimony you found the full daughter ion, the full daughter spectrum for the sock stain, it should be revealed in your report, correct?
No.
Sustain. Answer will stand, though.
If your opinion of the results on the graphs generated by Agent Martz's testing was that the full daughter spectrum was revealed in the sock stain, would you not include that in your report?
Not necessarily.
Don't you think that's an important finding, Dr. Readers?
The fact that I interpreted that as actually showing all three ions, I don't know whether it's important. I don't take myself that importantly, but it's a corroborative finding, yeah.
Sir, with respect to the determination as to whether or not a compound is indeed one that you've identified to the exclusion of all others, is it not important, sir, to find as many identifying characteristics and reveal them as you can to substantiate your finding?
Did you say to the exclusion of all others? I never said that, did I?
Did you?
I certainly did not. It's not, nothing is to the exclusion of all others. That's nonsense. We don't know all others, all the billions of compounds.
So you cannot say then that the substance found in the rear gate and the sock is EDTA from a preserved blood tube to the exclusion of all other compounds.
To the exclusion of all others, I can say it, but I'd be lying.
Then you will not say it, will you, sir?
I'm not going to say that, no.
And
Of course
looking at
not.
your report, sir, if you will, concerning the graphs generated for the analysis of the sock stain,
Yeah. Yeah. What
that's
about
paragraph 2, correct?
The what?
Paragraph 2 of your report.
Yes.
In that paragraph, you described seeing one parent and one daughter ion, correct?
I didn't describe seeing, I described the presence, or I state the presence of a retention time, a parent ion, and a daughter ion.
You did not put anywhere in this report that you saw the full daughter spectrum as you testified on July 24th.
I have not said anything like that in this report, that's correct.
And you filed no addendum to this report to indicate that, in fact, you had found the full daughter spectrum, not just one daughter ion, correct?
Would you repeat that, please?
You filed no correction or addendum to your report to reflect the fact that actually you'd found the full daughter spectrum and not just one daughter ion, correct?
Correct.
And you would agree, would you not, sir, that the more characteristics you can find that line up with a certain compound to identify it, the better it is in terms of confirming your findings? Wouldn't you agree?
Absolutely.
And so the finding of the full daughter spectrum was an important interpretation of the graphs, was it not?
It became an important issue, yes.
But it was not one that you included in your July 17th report.
That- Correct.
Now, after you wrote your July 17th report, sir, you were informed that Agent Marks tested his own unpreserved blood and got the same single parent and single daughter ion result that he found in the gate and the sock stain, correct?
Similar, yes.
Not the full daughter spectrum, but the single parent and single daughter. Isn't that correct?
Yeah, he never checked the second daughter.
Sir, did you observe his testimony?
Yes.
It was his testimony that he did not find the second daughter in his own unpreserved blood. Isn't that correct?
He never looked for it.
Sir,
He
did you
said
call...
very clearly he didn't run the 132 because he didn't think it was necessary. That's the third daughter on it. So he never looked for it.
Sir, isn't it true that he testified, not just that he didn't... Isn't it true that he testified that his blood, unpreserved blood, gave the same parent and single daughter ion results that were found on the gate and the sock? Wasn't that his testimony, sir?
I think he said similar, yes. Yeah.
And didn't you agree when I cross-examined you last you were here on July 24th that the results on Agent Martha's unpreserved blood were very similar to that of the gate and the sock?
I think I said the results that he obtained and that he graphs was from the unpreserved blood. Whether it in fact was unpreserved blood, I have no way of knowing.
And when I asked you, sir, whether or not you thought he was lying about that, you said no. You had no reason to doubt that he was being honest in saying he tested his own unpreserved blood. Do you recall that?
I don't recall it, but I'd agree with it. I don't think he's lying. I think he's mistaken in one way or another.
Well, sir, so after you wrote your July 17th report, which you agree shows the single parent and single daughter ion for both the gate and the sock stain, you learned of the result of Agent Martz's own unpreserved blood test. And after that, you came in to testify on July 24th, correct?
Yeah.
And then when you took the witness stand on July 24th, you had filed no addendum changing your findings that were indicated in the report, correct?
Objection. Asked and answered.
Sustained.
And when you testified, at that point only, you told this jury that you found the full daughter spectrum on the sock stain. Isn't that correct?
I didn't find it. I saw it, full daughter spectrum, yes.
You testified to your opinion that you saw the full daughter spectrum on those graphs on July 24th, correct?
No, wait. I saw the full data spectrum. It was presented to me. On it, I pointed out that you could really see all three, even though poorly, but you could see it.
That is your opinion, correct, Dr. Reeders?
I pointed it out. Obviously, it's my opinion, but I also left it for anyone else to form their opinion.
And Dr. Reeders, between the time that you testified that your interpretation and your opinion, the full daughter spectrum was found on the sock on July 24th, correct?
I think, was it the sock? I mean, it
Yes.
was one of them, that's all I know, yeah.
But your report does not reveal that you found the full daughter spectrum on the sock, which was written on July 17th, correct?
Asked and answered.
No, I did not.
What testing, if any, did you conduct between July 17th and your testimony on July 24th?
I didn't conduct any testing at any time, as I've repeatedly told you.
And did you review the graphs again between July 17th and July 24th?
Not as much in detail as I had before. I was asked things about some of them. I reviewed that. That's it.
Now, isn't it true, sir, that in order to overcome the very similar findings in Agent Martz's unpreserved blood to that of the gate and the sock stain, you decided to change your opinion concerning your interpretation of the graphs on the sock stain so that you could say that it was from preserved blood? Isn't that correct?
That's absolutely misleading and incorrect.
Well, sir, let me ask you this. Is there a difference in science between the term detected and identified?
Sure there is.
When you detect something, that means that it may be consistent with a compound, but isn't necessarily that particular compound that you're trying to look for.
Not necessarily. Detection can be so strong that it is at the same time a positive identification. Ordinarily, in the forensic toxicologic sequence of analysis, where what we call in forensic toxicology an forensically acceptable quantum of proof, you do two physicochemically independent tests. The first one, preferably, is one that is particularly sensitive, even at the sacrifice of specificity, and you call that a detection test. And then you do a second independent one, which is a corroboration or negation test. And so between the two, you have an identification as a basic requirement.
Then to boil it down, sir, if you have detection, you may or may not have the compound. If you have identification, you in fact have the compound.
No, you may or may not. You can't ever be sure. You go to the point of reasonable scientific certainty with the tools that you have and what you have available.
Then would you agree that there is a distinction, sir, between something that is presumptive for a certain compound and something that is identified as a certain compound? Is there a higher degree of certainty with respect to a compound that is identified than a compound that is determined to be presumptive for?
Presumptive can be as strong as identified. Any analysis that you do for a compound, if you get a result that fails to disprove its presence, is presumptively positive. If you have several different types of tests, all of them fail to rule it out by showing it could be there, then together between them, we call this reasonable certainty of identification. That's how we work that. That's the mental algorithm that's standard in this community. It means you don't prove anything, you fail to disprove. That's what you do.
Then you do not agree that there's a distinction between the terms detected and identified? Is that your testimony?
There's an obvious difference. They are two different words, and they require, in any particular case, definition.
then Dr. Readers, would you agree that identify implies a higher degree of scientific certainty than detected?
A high degree of scientific certainty for identification, yes, but not for presence or absence.
Yes, doctor, and presence or absence means it may or may not be there, correct? It may be there, but it may not. And when you say identified, it is a higher degree of scientific certainty. Isn't that true?
It still may be the compound, or it may be something else. It can always be difference. You have failed to disprove its presence. Every time you fail to disprove, you add another quantum to having identified it. You fail to disprove. You run a series of tests. If these tests are all positive, you have failed to rule out that compound. At one point or another, you say, I've done enough tests, I'm reasonably sure that's what it is, taking everything else into consideration.
All right, doctor, would you say, let me ask you a different question. There are such things as presumptive tests, correct?
Any single test is no more than a presumptive test.
Well, then, do you see any distinction between a test that is a presumptive test and a test that is a confirmatory test?
Yeah, confirmatory is done after the presumptive.
All right. So when something is done on a presumptive test and comes up positive, you say, we have a result that is presumptive for X, whatever it is you're looking for,
Right.
correct? And then when you go on and do further testing, you will confirm the presence or rule it out, correct?
Confirm it or negate it with the next test. If you do a third test, you do again the same process. It confirms the previous one or it negates the previous results.
And wouldn't you agree, doctor, that in mass spectrometry, you can only confirm a compound if you have the full daughter spectrum?
Absolutely not. It's nonsense. Whoever gave you that idea?
If people who were expert in the use of the tandem mass spectrometer said that that's what you had to do, would you disagree with them?
No, that's what they have to do. That's their opinion, but it isn't. Because, as I said before, it's not etched in concrete. It's not from Olympus.
All right, so it's
A
your...
lot of identifications in forensic science in MSMS are done on the basis of the parent ion and a single daughter ion. It's done every day with people who have that instrumentation.
Then your opinion is, Dr. Readers, that you're entitled to create your own standard for when something should be identified or not. Is that your
No.
testimony? Is it your testimony, sir, that you feel that you can make an identification based on your own criteria?
If they are only my own criteria, then they are junk science. If they are criteria which are shared by my colleagues, then I can say yes. You know, if they've stood the test of time and of cases.
But then it's your opinion, doctor, that you set your own standards and you determine whether or not a certain standard is correct or not.
You know, I don't set the standard.
If others disagree with the standards you have set, do you change your opinion?
Just because they have a different opinion? No, one debates it, and when comes a point where there's proof that one is right, the other is wrong, then you change your mind.
But you decide when that happens, isn't that correct?
Either I or the scientific community decides. Up until the point that there's a consensus, if people have my opinion, share my opinion, then we are a group that have one opinion. Somebody else has another opinion. Doesn't mean that either one is right. Eventually it turns out that one or the other one is right, or perhaps both are.
With whom did you consult to determine that your standard of a single parent and single daughter ion is sufficient to say that you have identified the presence of a certain compound in a mass spectrometer?
I looked in the literature, number one, on MSMS work. I have over the years many times because we've been considering getting into it.
What literature is that, doctor?
Huh?
What literature?
Scientific literature, technical literature from the ones that I looked at were from Finnegan, who makes the TSQ instrument that I think Dr. Martz used. Then Hewlett-Packard, who has put out that kind of an instrument, MSMS instrument.
And do those articles indicate that it's appropriate to identify the presence of a compound as opposed to just detect it on the presence of a single parent and single daughter ion? Is that what they say?
In some cases, yes, it is.
Could you produce those articles for us, sir?
No, I suppose I could if I went back and called them up to send me copies of them.
Could you please use the microphone, Dr. Readers? The court reporter's having a
Sorry.
hard time. And if others in the scientific community disagreed and felt that that the standard you have enunciated for us of a single parent and single daughter ion for the purpose of identifying a compound was inappropriate and too lax, you would simply disagree with them. Is that your testimony?
Yes, I would. I mean, they're entitled to their opinion, but it's not mine. They have no proof of that.
All right. Now, you indicated that there is a difference between presumptive and confirmed, correct?
It's a semantic difference, yes, but it's an important difference, but it is semantic. It refers to the first test, which no matter what it is, it's the first test. The second, physico-chemically independent test, then corroborates or negates, so it becomes the confirming or negating test.
Let me show you the last page of your report. Now, directing your attention, sir, to the last paragraph, which is labeled B, where you indicate, thus, the finding of EDTA in a microblood specimen, such as in the present ones, is consistent with, indicative of, and presumptive for the blood having originated from a specimen which has been placed into a usually lavender top blood collection tube, such as is commonly used to draw blood from a living person and keep it from coagulating. And the terminology you use in that paragraph, sir, is consistent with, indicative of, and presumptive for. Isn't that correct?
That's correct.
And in none of those words do you indicate the final or confirmatory language such as identify. Isn't that right?
Well, in this case, it's not a question of identified. When you talk about I guess so. It doesn't say identified that was it. That was EDTA blood from a tube, because you can't say that. You can only say this is EDTA blood. Presumably, because the most common source for it is a lavender top tube, it came from a lavender top tube. But it doesn't mean it did in fact come from that. It could come from other sources. I don't know where it came from, in short.
And the other sources it may come from, sir, well, let me ask you this. Are you aware that there are 4 different types of EDTA?
There are many more than 4, if you don't mind.
But at least 4, isn't that right?
There are more than 4. So there are 4, but there are also much more than 4.
And one is calcium disodium, isn't that right?
That's one of them, yeah.
And that's used for a food preservative, correct?
Calcium disodium EDTA is used for a lot of things, including treating lead poisoning.
Right. As well as a food preservative, isn't that right?
It's not a preservative. What it does, it ties up metals and keeps the color and flavor of food intact. It doesn't keep it from rotting.
Are you aware that it's also used as a food preservative? Did you know that?
It doesn't work as a preservative. Preservative means prevents bacterial degeneration. It doesn't do that. It's not an antibacterial compound.
If I were to show you, sir, an article, a page out of the Merck Index, indicating that calcium disodium was in fact used as a food preservative along with the purpose of treating lead poisoning, would you change your opinion, sir?
Of course not. It's a preservative of color and flavor, but not of food as edible food. A food preservative is something which keeps food edible, and this won't do it. It'll be bacterially degraded, just as if you didn't have it in there.
All right, then it's your testimony that although it may not preserve food, it's a color retentive product
In
for the
some
food?
cases, look what it does. It ties up the metals that oxidize color and flavor. It inactivates them. That's its purpose in food.
All right, then it is used in food, though, is it not?
Yes, it is, sure.
All right. And then there's disodium only, correct?
Huh?
Disodium, I'm talking about the types of EDTA. There is also disodium, straight disodium.
Disodium EDTA is another one that's disodium dihydrogen EDTA, which when you put it into food, it usually very quickly goes to either calcium or, depending on what, mostly calcium.
All right. And then there's sodium EDTA, correct?
Yep,
And there's trisodium EDTA.
yep. There are many others, as I said.
Now, the way the anticoagulant works is that it binds up the calcium in your blood, which is a clotting agent. Is that right?
That's the anticoagulant effect, yes.
Now, do you know which form? We've just gone through 4 of the forms of EDTA. Do you know which of those can be used as a food preservative, sir?
You can use any one of them because the purpose of it is to tie up iron, copper, and a few other heavy metals which cause changes in color and changes in flavor. So you can use any one of them from a technical point of view, provided the acidity or basicity of the food is properly adjusted. The trouble is that the free EDTA isn't very water soluble. The sodium EDTA is.
Now, do you know whether these forms of EDTA were ever tested for the purpose of determining what the maximum tolerance would be in a normal, healthy person?
You mean in food, is that it? And say maximum tolerance how? Intravenous or in food or what?
No,
Vast
sir. I asked
difference.
you whether there was any testing that you know of that determined whether any of the forms of EDTA that we have just talked about, those 4,
Right.
was ever done to see what the normal level would be in an average healthy person.
Yes, the study of Foreman and Trujillo dealt with normal healthy persons,
Your Honor,
and in
objection,
it they
non-responsive.
determined the,
Non-responsive.
Overruled.
and in this they determined what the level in their blood was, which was in the low parts per billion below their detection limit.
All right, ladies and gentlemen, we need to take a comfort break for the jurors. We'll take 10 minutes. All right, thank you, counsel. Proceed.
All right, Dr. Reeder, when I questioned you when you were last here on July 24th, I asked you whether testing had been done to determine what the average level of EDTA might be in the average healthy person, and you agreed there had not been such a test. Do you recall that testimony, sir?
I recall the testimony that there had not been a population study, as one generally as ATSDR and other agencies do, that I know of.
That would determine what the average level, if there is one, of EDTA in the average healthy person, correct?
Except for the small Foreman and Trujillo sample.
I am talking, sir,
That's a sample.
I've asked you, that test was not conducted to determine what the average level might be in a healthy person of EDTA. Isn't that correct, sir?
I don't know what it was conducted to, but it gave you that information in the small number of people.
Sir, do you recall testifying on cross-examination back on July 24th that was not the purpose of that testing back in the 1950s?
I'm sure that wasn't the purpose of the testing to determine the world population, but it was to measure the normal in those people, among other things.
Sir, do you recall testifying that with respect to that paper, they were attempting to inject EDTA for the purpose of going into studies about how it would chelate with lead poisoning and tracing it through the body? Isn't that correct?
No, that particular paper is to study the pharmacokinetics of what the body does to EDTA. That's what the purpose of that paper was. And that includes determining that it is not detectable when you don't give it, or that after you give it, after a period of time, it disappears. It doesn't stay in the body. That's what the Foreman and Trujillo paper was, and they repeated that with some additions in a book that came out a couple of years later from a symposium.
As a matter of fact, sir, isn't it true, actually, that study found that it would pass through the body with the exception of about 5%, correct?
No, oh, no. Either you don't understand it or you're saying the wrong thing.
But objection, Your Honor. After no, it's non-responsive.
Yes. Next question.
Dr. Reeders, isn't it true that study made no effort to determine whether average healthy people had a certain trace amount of EDTA in their blood at any given time? Isn't that true, sir?
No, I don't think so.
You think that was the purpose of that study? Is that your testimony?
One of the purposes that the baseline was something or zero. That's what it's part of it, yes. In those people.
They took a few people and they injected them with EDTA. Isn't that correct?
Among other things, that's what they did.
What test do you know of, sir, that took average people who had not been injected with anything to determine whether some form of EDTA was present in their blood? What test can you tell us about?